The Schmeck's industry is a multi-billion-dollar business, but it's also a place where unethical and criminal conduct occurs, which makes it ripe for HR issues. And today we are going to talk about a group of exotic dancers who asserted their rights. Welcome to the HR Insider. Hi, I'm Harlow Reed. Today we are talking about exotic dancers, specifically those who did not have an HR department and the steps that they took to assert rights that they were entitled to receive. At the end of this video, I'm also going to include some helpful tips that I think could benefit you if you find yourself in a similar situation. So stick around. Let's talk about it. The content shared on this channel is for informational purposes only and is not a substitute for professional legal advice. So always consult with a qualified attorney or HR professional for specific guidance tailored to your needs. And don't forget to like and subscribe. This story begins with Carenza Clincy. She was a nude female exotic nightclub dancer at Club Onyx from June 2007 to fall of 2010. Jack Galardi was the CEO and controlling shareholder at that time, and the defendant named by Clincy was Michael Kapp, who was the chief operating officer of Jack Galardi's businesses. Carenza referred to Onyx throughout her entire case as a strip club, and so we're just going to call it that. That's what she referred to it as. And I think that's what most people would know it as, Atlanta, Georgia. And the club offered a number of services. They offered a full service bar, they had televisions, pool tables, VIP rooms, dining options. So it really was a very large establishment that would have a night manager, a relief manager, a general manager, and all of these people who helped to support this thriving business. Rick Hayes was the general manager of Onyx, and he had actually worked at the club since 2006. Now, the day to day operations, the decisions that are made about people who come there to work, those are made by the management team unless the general manager, Rick Hayes, decided that he wanted different operational instructions to be carried out. So Carinza Clincy was not the only employee who filed suit against the strip club. There were other dancers who also filed similar suits, and they were eventually joined together in one lawsuit. Now, one of the central issues was the classification of the dancers as independent contractors. So while they were working there, Carenza and the other dancers discussed how much their jobs were limited by the things that were being done by strip club management. For example, they had to work on certain days, they had to work a certain number of hours. If they didn't follow the rules of the club, they were denied, they were penalized. They either couldn't be scheduled to work or they had to pay, pretty substantial fines. Had very little control and had asserted this concern to the club management that did not have an HR department, but they did have a general manager, and they voiced these concerns to the general manager. Now, a lot of times with some of these business operations who are not familiar with HR laws and employment laws, they're going to go with whatever they think is necessary for business operations. Unfortunately, there is oftentimes a conflict, and you have to be able to understand how employment laws. So if you're someone who doesn't understand some of those nuances and how those laws work, then you're going to go with what's best for business operations. And this is exactly what happened with the leadership at the strip club. They basically said, well, we don't care what you think, Carenza, about, your penalties. These are the rules of this club. And if you want to work here, then you're going to have to follow them. After that, Carenza did file a lawsuit. She was one of the first dancers to file a lawsuit, and then others did. But what happened almost immediately after the club was notified is they started terminating every single dancer. And I shouldn't say terminating because they had them classified as independent contractors, but that's essentially what it was. They told them they couldn't work there anymore because they were suing them. Of a leader who is heavy in operations, who does not understand employment laws and how human resources work and how you need to manage HR issues when you are applying rules to a workforce. You can't just go with it based on what is in the best interest of the organization. In this case, there was a retaliation claim that was piled onto the original claim of misclassification of workers. And again, businesses such as this one operate from two lanes. The first lane is I'm going to do what's best for business operations. I have a business to run. I am focused on that, and I need this business to be successful. I am not going to pay attention to what the laws say I can and cannot do with the people that I hire to work in my business. And then the second group would say, I have a business to run. I'm familiar with the laws of what what is said about what I can and cannot do with my workers who are in this business with me, helping me to make this business successful. But I don't care what those laws say. And I'm willing to take a risk about what those laws say. And I want to just take a moment to applaud these ladies. I know they won't hear this video, but my goodness, I can't imagine the courage that it took for them in this kind of a vulnerable industry. This is an industry for women that is not one that is looked upon with pride and respect, and that perception of who people are who work in strip clubs is carried out through how they are treated in at the club, how they're treated by people who frequent the club, and how society generally views them. And so I just think it took a lot of courage for them to stand up and say, "Listen, you're penalizing us. You're not allowing us to schedule make our own schedules, and we are losing money, and by the way, what you're doing to me, to us, to all of us is not fair. And so we want to do something about it." And they did this while they were employed. And the feeling of threat, I mean, I don't know, maybe they felt comfortable with the leadership team, but oftentimes these things can become dangerous. A lot of people who work in, strip clubs have addictions. They have issues. They are vulnerable people in society. A lot of courage. And it's a story for all of us to be inspired by, in terms of what we can do in the workplace if we are confronted with issues that we don't feel are fair. How do laws like the Fair Labor Standards Act, which governs the claim that was brought by the dancers, how is it managed when there is no HR department present at an employer's location? From a duty to comply standpoint, it simply does not matter. Ignorance is no excuse for gaslighting and projection and lying and manipulation. May work on relationships, but it doesn't work in the federal government. The federal government doesn't care if you have an HR staff, and they don't care if your focus is business operations. You have to classify your employees properly. So let's go through some key takeaways from this case. Some of the things that you can do if you find yourself in an employment situation where you don't have an HR department, you're voicing concerns, and you just don't know what to do. The first thing is, watching videos like this is a great first step because it helps you understand your rights and understand how certain laws apply to you. So familiarize yourself with local, state, federal labor laws, wage laws, discrimination laws, workplace safety laws. These are all the things that we cover on particular channel, and I think it would be beneficial for you to watch some other videos to help you understand how your circumstances might be impacted and might apply to other regulations. The second thing is document everything, and I mean detailed records. You want a log of what has happened to you, who's spoken to you, any relevant evidence. In this situation, we were talking about people who were working at a strip club. The great case where we're talking about the Fair Labor Standards Act and clearly showed that they were not independent contractors, right? They couldn't work their own schedule. They had to work a certain number of hours. So they were handing out pamphlets and rules to the strippers. But in your case, they may be sending you emails. So you just want to make sure that you are printing and tracking those things. There are government agencies that help employees who are struggling with understanding what their rights are. You've got the Equal Employment Opportunity Commission. Department of Labor. I mean, many of the agencies inside the Department of Labor would be a great help to you. Don't just go and look someone up on Google. Contact the Americans with American Bar Association. They are an excellent resource, not just for advocacy groups, but they can also link you with attorneys who might take cases on pro bono. Lawyer knows that you have a good case, they will work with you. A lot of these cases, they do go on for a very long time because big employers have lots of lawyers and they will try to make this thing linger on for years and years and years. So you just have to be in it for the long fight. It's not something that happens overnight, especially if you're dealing with a larger employer, like some of the other employers we've reviewed. The fourth thing you can do is make sure you have a support network. Coworkers, collaborate with them. There are protections for employees to have the right to collaborate and talk about their environment, talk about their pay. The National Labor Relations Board, they can pursue collective action. So you're protected there. And in this case, we saw how these employees, they exercised their right, they filed a suit, they were terminated, and the employee or ended up having to pay a substantial sum. It was over $1 million that they had to pay. Follow the path of direct communication. I know that a lot of people feel uncomfortable with doing this. They don't feel like HR is on their side, and I understand that. But unfortunately, you do need to give your employer an opportunity to address your issue. What I always say, go back and look at my video, When to Contact HR. I say you need to have a plan A, B, and C. What I mean, if you voice your concerns and plan A happens, what are you going to do? Plan B happens, what do you want to do? If they terminate you, that's plan A. This is my path if they terminate me. If they allow me to continue work and they begin to harass me, this is my plan B. If they actually try to fix the issue, this is my plan C. So just make sure you have a plan in mind of how you're going to deal with these issues once you do explore that direct path with your employer to try and resolve it. That's actually what these they approached their supervisor and said, listen, I'm having some challenges here with the fact that you are being so controlling, but I'm an independent contractor. And the employer said, well, too bad. And they filed a lawsuit. As a last resort, you will have to file a lawsuit. Even without HR, workers like exotic dancers have rights protected under the law, and you do too. This case, Clincy v. Galardi, shows us that standing up for those rights matter. I hope you enjoyed today's video. Please remember to leave a comment. Let me know what you think about this video. Hit the like and subscribe button and ring that notification bell. Thanks so much. See you next time.